Okay, right. Start. The Supreme Court of India is currently hearing a significant challenge to the constitutional validity of preventive detention laws, particularly the National Security Act (NSA) and the Unlawful Activities Prevention Act (UPA). The petitioners, including human rights organizations and legal activists, argue that these laws grant excessive powers to the executive, allowing individuals to be detained without trial for extended periods. They contend that such provisions violate Articles 21 and 22 of the Constitution, which guarantee personal liberty and protection against arbitrary detention. The petitioners cite landmark cases such as A.K. Gopalan versus State of Madras 1950 and Menka Gandhi versus Union of India 1978, arguing that any restriction on personal liberty must pass the test of reasonableness and procedural fairness. They contend that the NSA and UPA allow for prolonged detention without adequate judicial review, violating fundamental principles of natural justice. The petitioners also argue that the broad and vague definitions of national security and unlawful activity enable misuse of these laws against journalists, activists, and political opponents. On the other hand, the Union government, represented by the Solicitor General, defends the necessity of preventive detention laws to safeguard national security and maintain public order. The government contends that terrorism and insurgency-related threats require stringent legal measures to prevent individuals from engaging in activities that may endanger national integrity. The respondents argue that judicial intervention should be minimal in matters concerning national security and that existing safeguards such as review boards and advisory panels provide sufficient oversight. During the hearings, the Supreme Court examines whether preventive detention laws meet the constitutional mandate of proportionality and reasonableness. The bench questions whether these laws strike an appropriate balance between national security and individual freedoms. The court also seeks data on the number of preventive detention cases, the duration of detentions, and the conviction rates in such cases. Recognizing the significance of the issue, the Supreme Court appoints a committee to review the procedural safeguards available under the NSA and UPA. The court also directs the government to submit a comprehensive report detailing instances where these laws have been used and whether any cases of wrongful detention have been identified. The final judgment, expected in early 2026, is likely to have a profound impact on the future of preventive detention laws in India. The verdict may lead to the introduction of additional safeguards to prevent misuse or even the reconsideration of certain provisions of these laws.